I stood in my backyard on a Tuesday morning in March, staring at the 6-foot cedar fence I had just finished installing the previous weekend, when I heard the shrill voice that would haunt my next 6 months. "Excuse me. Excuse me." The woman marching across my lawn wore white caprice and a visor despite the overcast sky. Her highlighted hair bounced with each aggressive step. "I'm Patricia Henderson, president of the Meadowbrook Hills HOA, and that fence is in direct violation of our community standards." I set down my coffee mug on the patio table and walked toward her, extending my hand. "Ethan Vaughn. Nice to meet you. What seems to be the problem?" She ignored my hand completely, pulling out a laminated binder from her oversized purse. "This fence exceeds the height restriction by a full foot. The stain color isn't on the approved list, and you didn't submit the proper paperwork for exterior modifications." Her voice had that particular quality of someone who had practiced this speech multiple times in front of a mirror. I took a deep breath. "Actually, I did submit the paperwork 6 weeks ago. I never heard back, so after the 30-day waiting period specified in the bylaws, I proceeded with the installation." Patricia's face flushed red. "Well, I never received any such paperwork, and ignorance of the rules is no excuse. This needs to come down immediately, or we'll be forced to take legal action." "Legal action over a fence?" I couldn't help the incredulous tone in my voice. "The rules exist for a reason, Mr. Vaughn. Property values don't maintain themselves." She snapped her binder shut with unnecessary force. "You have 2 weeks to remove it, or you'll be hearing from our attorney." She pivoted on her heel and marched back across my lawn, leaving small divots in the grass from her wedge sandals. I stood there, coffee getting cold, wondering how my peaceful Sunday project had just turned into a potential lawsuit. I had moved to Meadowbrook Hills in Austin, Texas, 8 months earlier, excited about the spacious backyard and the privacy it would provide. The neighborhood was one of those planned communities built in the early 2000s, full of cookie-cutter houses and streets named after trees that didn't actually grow in Texas. When I bought the place, the real estate agent had glossed over the HOA restrictions, assuring me they were pretty standard stuff. The fence had been necessary. My neighbor to the east, an elderly man named George, had 2 German shepherds that loved to wander. They were friendly dogs, but they had a habit of doing their business in my yard and digging up the flower beds I had spent weeks establishing. George was apologetic, but seemed physically unable to keep up with the dog's escape artistry. The fence solved the problem while maintaining good relations. That afternoon, I dug through my filing cabinet and found the copy of my HOA application, complete with detailed drawings, paint samples, and measurements. I had followed every guideline in the community handbook. The fence was 6 feet tall, which was the maximum allowed height. The stain was cedar natural, which was literally the 3rd option on the approved colors list. I had proof of certified mail delivery to the HOA office. I called my buddy Marcus, who worked as a paralegal downtown. "Man, they can't do anything if you followed the rules," he said through a mouthful of what sounded like a sandwich. "Keep all your documentation. If they want to play hardball, let them." 2 weeks passed. I almost thought Patricia had forgotten about her threat. Then, on a Monday morning in early April, a process server appeared at my door with a court summons. The Meadowbrook Hills Homeowners Association was suing me for $15,000 in damages and demanding the immediate removal of my fence. $15,000. For a fence that cost me $1,200 to build. I sat at my kitchen table, reading through the legal complaint. According to their filing, my fence was an eyesore that diminished property values, violated multiple community standards, and set a dangerous precedent for lawlessness in the neighborhood. The language was absurdly dramatic, as if I had erected a spite fence made of rusted metal and barbed wire, instead of a perfectly normal cedar privacy fence. I needed a lawyer, which meant money I hadn't budgeted for. I had just started a new job as a software engineer at a tech startup, and my savings were already stretched thin from the down payment and moving expenses. But I wasn't about to let Patricia and her HOA bully me into tearing down a perfectly legal fence. I found an attorney through a referral from Marcus. Her name was Jennifer Walsh, and she specialized in property disputes and HOA conflicts. Her office was in a converted house in South Austin, painted purple with orange trim, very Austin weird. HOA cases are my bread and butter, Jennifer said during our consultation, flipping through the documents I had brought. She was in her mid-40s, with short gray hair and reading glasses on a beaded chain. And I've dealt with Patricia Henderson before. She's president of 3 different HOAs in the area. Real piece of work. So what are my chances? I asked, honestly. Pretty good if everything you're telling me is accurate, but here's the thing about HOA disputes. They almost never go to trial. These organizations have war chests full of dues money, and they're not afraid to bury you in legal fees until you give up. Most people can't afford to fight, so they fold. I'm not folding, I said. Jennifer smiled. Good. Then let's make sure we do this right. First thing I want is a professional land survey. Your property line, their property line, everything documented by a licensed surveyor. Why? The fence is completely on my property. I measured it myself from the stakes. Trust me on this, Jennifer said. In my experience, HOAs that get aggressive about property modifications usually have something to hide. Let's make absolutely sure we know where every boundary line sits. I left her office $2,000 poorer, but feeling slightly more confident. The survey company she recommended, Precision Land Surveying, could come out within the week. The surveyor was a weathered man in his 60s named Tom Bradshaw. He arrived on a Thursday morning with a younger assistant, both wearing high-visibility vests and carrying equipment that looked like it belonged in a science fiction movie. Tom had been surveying properties in Travis County for 38 years, and he had the casual confidence of someone who had seen everything. Nice fence, he said, walking the perimeter of my yard. Good construction. You do this yourself. With some help from my brother, I replied. Built it over 2 weekends. Tom nodded approvingly. He set up his equipment, something called a total station that used lasers to measure distances with incredible precision. His assistant held a prism pole at various points around the property, while Tom recorded measurements and consulted what looked like original plat maps from the county records. They worked for 3 hours, meticulously documenting every corner of my lot. I went inside to work remotely, checking on them periodically through the window. Around noon, Tom knocked on my door with an expression I couldn't quite read. "Mr. Vaughn, you're going to want to see this," he said. We walked to the back corner of my property, where my fence met the property line shared with the HOA common area, a strip of land that ran behind all the houses on my street. Tom had placed several bright orange stakes in the ground. These orange stakes represent the actual property line according to the plat map and deed records, Tom explained. Now, see that brick retaining wall over there, the one on the HOA common area. I looked at the decorative brick wall that bordered a small drainage pond. It was about 3 feet high, well maintained, with the HOA logo embedded in a concrete marker. Yeah, what about it? That wall is on your property. Has been since it was built, probably 15 years ago based on the weathering. The HOA built it approximately 4 feet onto your land. I stared at him. "Are you serious?" Tom pulled out a tablet and showed me a detailed diagram. The property line cut right through the middle of the brick wall. The entire wall, the decorative plants around it, and a portion of the drainage pond maintenance area were encroaching on my property. "I'm very serious. This is a clear encroachment. They've been trespassing on your land for over a decade." Tom's assistant was already taking photographs and measurements of the wall from multiple angles. A slow realization dawned on me. That's why Patricia was so aggressive about the fence. If I had hired a surveyor before building it, I would have discovered their encroachment. "Probably," Tom agreed. "And here's the thing about adverse possession in Texas. If someone openly uses your land for 10 years without your permission, they can potentially claim legal ownership of that portion. But you just moved here 8 months ago, which means the clock resets. The previous owner could have made a claim, but you can't. So what does that mean for me? It means the HOA has been using your land without permission or compensation. They either need your explicit permission to keep that wall there, or they need to remove it and restore your property." Tom handed me a folder. "I'll have the full survey report ready in a few days, but this is enough to get started." I called Jennifer immediately. She answered on the second ring, and I could hear traffic in the background. "Our surveyor found that the HOA built a retaining wall on my property," I said without preamble. 4 feet of encroachment. There was a pause. Then Jennifer laughed, a sharp bark of amusement. "Oh, that's perfect. That's absolutely perfect. Email me the preliminary findings right now. We're filing a counterclaim." The next few days were a blur of legal documents and preparations. Jennifer drafted a comprehensive counterclaim, alleging that the HOA had knowingly encroached on my property, demanded removal of all structures on my land, and sought damages for unpermitted use of my property dating back to when the wall was originally constructed. She also filed a motion to dismiss the HOA's original lawsuit as a retaliatory action designed to prevent me from discovering their encroachment. "The best defense is a good offense," Jennifer said during a phone call on Tuesday. "We're going to make them very uncomfortable." The court date was set for mid-May, about 6 weeks away. In the meantime, I had to deal with increasingly hostile interactions with the HOA board. Patricia started sending me violation notices for the most ridiculous things. My grass was allegedly a 1/4 inch too long. My mailbox needed repainting. My garbage cans were visible from the street for 20 minutes past the pickup time. Each notice came with threats of fines and further legal action. "This is harassment," I told Jennifer after the 5th notice in 2 weeks. "Yes, it is. Document everything. It strengthens our case." She sounded almost pleased. I started taking photographs with timestamps for everything. My lawn height compared to my neighbors, my perfectly fine mailbox next to others in worse condition, even video of the garbage truck's arrival and departure times. I created a spreadsheet tracking every interaction with the HOA. My neighbors began to notice the tension. George, the elderly man with the dogs, stopped by one evening in late April with a 6-pack of beer. "Heard Patricia's giving you hell," he said, settling into one of my patio chairs with a grunt. "She tried the same thing with me 3 years ago. Wanted me to tear down my shed, said it was 2 inches too close to the property line. What happened? I paid her off." George took a long drink from his beer. "Not officially, of course, but I made a voluntary contribution to the HOA's legal defense fund, and suddenly the shed was fine." That's how she operates. Finds some violation, threatens legal action, and people pay up rather than fight. That sounds like extortion. It is extortion, but it's hard to prove, and most folks just want to avoid the hassle. George gestured at my fence with his beer bottle. You're the first person I've seen actually fight back. Half the neighborhood is rooting for you. Just half. The other half are terrified she'll come after them next if you win. Another neighbor, a woman named Michelle who lived 2 houses down, knocked on my door a few days later. She was a pediatric nurse, single mom to 2 teenagers, and apparently had her own history with Patricia. "I saw your fence when you were building it," Michelle said. "It looked completely normal to me. Patricia is just on a power trip. She's been president for 6 years and it's gone to her head." "Have you had issues with her?" "Last year, she tried to fine me because my son's car was parked in the driveway instead of the garage. Said it was an eyesore because it's an older model. Never mind that half the board members have boats and RVs parked in their driveways." Michelle crossed her arms. "If you need a witness statement or anything, let me know. I'm happy to help." The support was encouraging, but it also highlighted how much fear Patricia had instilled in the community. People were afraid to challenge her openly, even when they disagreed with her actions. Tom delivered the final survey report in the first week of May. It was a thick binder with detailed maps, photographs, legal descriptions, and a comprehensive analysis of the encroachment. His findings were unambiguous. The HOA had built a retaining wall, installed landscaping, and maintained a portion of the drainage system on my property for approximately 15 years, without the permission of any previous property owners. Jennifer filed an amended counterclaim with the new evidence. She also sent a formal demand letter to the HOA's attorney, outlining the encroachment and demanding either compensation for past use or immediate removal of all structures on my property. The response came 3 days later. The HOA's attorney, a man named Richard Blackwell, sent a dismissive letter claiming that the survey was inaccurate and that the retaining wall had been properly placed according to the original development plans. He offered no evidence to support this claim. "They're bluffing," Jennifer said. "They don't have a leg to stand on and they know it. So why keep fighting? Because backing down means admitting fault, and that opens them up to liability. If they've done this to you, they've probably done it to others. Admitting one encroachment could trigger a domino effect of lawsuits." The week before our court date, I received an unexpected visitor. Richard Blackwell himself showed up at my door on a Wednesday evening, carrying a leather briefcase and wearing an expensive suit. "Mr. Vaughn, I was hoping we could talk off the record," he said with a practiced smile. "May I come in?" Against my better judgment, I led him into my living room. He declined my offer of water and got straight to business. "My clients are prepared to drop their lawsuit against you," Richard said. "In exchange, you agree to allow the retaining wall to remain on your property, and we'll grant you a variance for your fence." Everyone walks away happy. "And what do I get for letting your clients continue to encroach on my property?" "Peace of mind. No legal bills." "The satisfaction of keeping your fence." Richard leaned forward. "Look, I'll be straight with you. This is a stupid fight. Your fence is fine. Patricia Henderson got her ego bruised and overreacted. But if this goes to court, you're going to spend thousands on legal fees, waste months of your life, and even if you win, collecting damages from an HOA is like squeezing blood from a stone. Your clients built on my property without permission. That's trespassing. It was an honest mistake made 15 years ago by a contractor who probably misread a survey stake. It's a 3-foot-tall decorative wall, not a spite fence. Be reasonable." I stood up. "I think you should leave. Any further communication can go through my attorney." Richard's friendly demeanor evaporated. "You're making a mistake. Patricia doesn't forgive easily. Even if you win in court, you still have to live in this neighborhood." "Is that a threat?" "It's a reality check." Richard picked up his briefcase. Think about what kind of life you want to have here. After he left, I immediately called Jennifer and told her about the conversation. That was absolutely a threat, and it was incredibly stupid of him to make it in person, she said. Write down everything he said, word for word, while it's fresh. We might be able to use it. The court date arrived on a warm Tuesday in mid-May. I took the day off work and met Jennifer at the Travis County Civil Courthouse downtown. The building was a modern structure with lots of glass and metal, nothing like the old limestone courthouses you see in smaller Texas towns. Patricia was there with two other HOA board members. A thin man in his 50s named Donald, who apparently served as treasurer, and a younger woman named Stephanie, who took notes on everything with manic intensity. Richard Blackwell was conferring with them in hushed tones near the courtroom entrance. Jennifer had warned me that the actual hearing would probably be brief. This was a preliminary hearing to address the motions and determine whether the case would proceed to trial. The judge, a woman named Carolyn Martinez, had a reputation for no-nonsense efficiency. We were called into the courtroom at 10:30. Judge Martinez was a stern-looking woman in her early 60s with iron gray hair pulled back in a tight bun. She reviewed the documents in front of her for a few minutes while we all sat in silence. "All right," she finally said. "Let me make sure I understand this situation. The HOA sued Mr. Vaughn over a fence that appears to comply with community standards. Mr. Vaughn countersued claiming the HOA has encroached on his property with a retaining wall. Both sides have filed motions to dismiss the other's claims. Is that correct?" "Yes, Your Honor," both attorneys said simultaneously. Judge Martinez looked at Richard. "Mr. Blackwell, what evidence do you have that Mr. Vaughn's fence violates HOA standards?" Richard stood. "Your Honor, the fence was built without proper approval from the Architectural Review Committee. While Mr. Vaughn claims he submitted paperwork, the committee has no record of receiving it." "Your Honor, if I may," Jennifer interjected, standing up. "We have proof of certified mail delivery to the HOA office, including signature confirmation. The bylaws clearly state that after 30 days without a response, approval is considered granted by default." Jennifer handed several documents to the bailiff, who passed them to Judge Martinez. The judge reviewed them carefully. "These appear to be legitimate proof of delivery," Judge Martinez said. "Mr. Blackwell, does your client have any explanation for why this paperwork was never reviewed?" "The HOA office receives hundreds of documents, Your Honor. It's possible it was misfiled." "Convenient," Judge Martinez said dryly. She turned her attention to the counterclaim. "Now, regarding the encroachment. Miss Walsh, you've submitted a professional survey showing that the HOA built a retaining wall on Mr. Vaughn's property. What say you to this, Mr. Blackwell?" Richard stood again. "Your Honor, we dispute the accuracy of that survey. The retaining wall was built according to the original development plans, which showed it to be on HOA common land. Do you have documentation to support that? Original surveys, construction permits, anything?" There was a long pause. "We're working on obtaining those records, Your Honor. They're quite old." "I see." Judge Martinez made several notes. "Here's what's going to happen. Mr. Blackwell, your client's lawsuit against Mr. Vaughn is dismissed with prejudice. The fence clearly complies with HOA standards based on the evidence presented, and Mr. Vaughn made good faith efforts to follow proper procedures." Patricia's face went red. She whispered something urgently to Richard, who gestured for her to be quiet. "As for the counterclaim regarding the encroachment," Judge Martinez continued, "this requires a full hearing with expert testimony. I'm scheduling a trial for July 15th. Mr. Blackwell, if your clients have any documentation supporting their position, I suggest you find it before then. This court takes property rights very seriously. Your Honor, my clients would like to request, Richard began. Your clients have requested quite enough, Judge Martinez interrupted. July 15th, 9 a.m. If the parties reach a settlement before then, notify the court. Otherwise, I'll see you all back here. We're adjourned. The gavel came down with a sharp crack. Outside the courtroom, I felt like I could finally breathe. Jennifer was practically glowing. That went even better than I expected, she said. Having their lawsuit dismissed with prejudice means they can't refile it. And Judge Martinez clearly isn't buying their excuses about the encroachment. Patricia stormed past us without a word, her heels clicking angrily on the marble floor. Donald and Stephanie hurried after her like confused ducklings following their mother. What happens now? I asked. Now we prepare for trial. We need to quantify damages for their use of your property. I'm thinking we should consult with a real estate appraiser to determine the rental value of that land over the past 15 years. Wait, I can charge them rent for land they took from me. Absolutely. It's your property. They used it without permission or compensation. Fair market rental value is a standard measure of damages in encroachment cases. Over the next few weeks, Jennifer hired a real estate appraiser named Susan Chen. Susan examined the property, reviewed comparable rental rates for similar land, and calculated that the fair market value for renting approximately 120 square feet of land in an established Austin neighborhood for 15 years came to roughly $18,000, plus interest. Of course, the previous owners would technically be entitled to the damages for the years they owned the property, Jennifer explained. But we can make an argument that you're entitled to future damages unless they remove the encroachment. The point is to establish that this isn't a trivial matter. They took something that wasn't theirs. I also started digging into the HOA's history. Public records showed that Patricia Henderson had been president for 6 consecutive 2-year terms. The bylaws technically allowed for term limits, but there was some loophole about uncontested elections. Patricia ran unopposed every time because she had cultivated a board of loyalists who supported her unconditionally. More interesting were the HOA's financial records, which were supposed to be available to all homeowners. When I requested copies, I was told there would be a processing fee of $200. Jennifer sent a letter threatening legal action, and suddenly the records appeared in my email inbox for free. The finances were a mess. The HOA had spent over $40,000 on legal fees in the past 2 years alone, mostly on disputes with homeowners over minor violations. Patricia's voluntary contribution system that George had mentioned seemed to be a real thing. There were dozens of unexplained deposits labeled as settlement agreements or compliance contributions. This is looking more and more like a pattern of abuse, Jennifer said when I showed her the records. If we can prove systematic harassment for financial gain, this gets a lot more serious. In mid-June, about a month before the trial, I received a settlement offer. The HOA would pay me $5,000, admit no wrongdoing, and I would grant them an easement to keep the retaining wall on my property in perpetuity. That's insulting, I told Jennifer. They caused me more than $5,000 in legal fees alone. Want a counteroffer? What would be fair? Jennifer thought for a moment. They remove the wall and restore your property at their expense. They pay your legal fees in full. They pay $10,000 in damages for past use of your land, and Patricia Henderson resigns as HOA president. You think they'd agree to that? Not a chance, but it establishes that we're serious and we're not desperate for a settlement. We sent the counteroffer. Richard Blackwell called it unreasonable and vindictive. No further settlement discussions occurred. As July approached, I noticed something strange. The HOA stopped sending me violation notices. The constant harassment just ceased. George noticed too. "They're scared," he said during one of our evening beer sessions. "Word is getting around about what you found. Patricia's been real quiet lately at the board meetings." "You go to board meetings?" "Sometimes. When I'm bored." Last one was interesting, though. Someone asked about the legal fees, wanted to know why the HOA was spending so much money on lawsuits. Patricia got real defensive, said it was all necessary to maintain property values. What did people say? Most were too intimidated to push back, but there were a few rumblings. People are starting to ask questions. George finished his beer. "You've got more support than you think." The trial was scheduled for a Wednesday in mid-July. Jennifer had prepared extensively, organizing all our evidence into a clear, compelling narrative. We had the survey, photographs, property records, financial documents, and witness statements from both Tom the surveyor and Susan the appraiser. The night before the trial, I barely slept. I kept running through potential scenarios, worrying about what ifs and worst-case outcomes. Around 2 in the morning, I gave up on sleep and sat in my backyard, looking at the fence that had started all of this. It was a good fence. Straight, sturdy, well-built. It had solved the problem with George's dogs and given me the privacy I wanted. I didn't regret building it for a second. The courthouse was busy when I arrived Wednesday morning. Jennifer met me at the entrance, looking crisp and professional in a navy suit. "Ready?" she asked. "As ready as I'll ever be." The courtroom was the same one we'd been in for the preliminary hearing. Judge Martinez took the bench promptly at 9, and we began. Jennifer presented our case methodically. She called Tom Bradshaw first, who explained the surveying process and his findings in clear, accessible language. He used blown-up diagrams and photographs to show exactly where the property line fell and how the HOA's retaining wall encroached on my land. "In your professional opinion, Mr. Bradshaw, was this encroachment obvious from the property records?" Jennifer asked. "Yes, madam. Anyone conducting a proper survey would have identified it immediately. The property line is clearly marked in the county plat records." So the HOA should have been aware of this when they constructed the wall. Either they should have been aware, or they failed to conduct proper due diligence before building on land they didn't own. Richard Blackwell's cross-examination was brief and ineffective. He tried to suggest that survey measurements could vary and that boundary lines weren't always precise. But Tom calmly explained that modern surveying equipment was accurate to within inches, and there was no ambiguity in this case. Susan Chen testified next about property values and rental rates. She explained her methodology for calculating damages and presented a figure of $18,000 for 15 years of unauthorized use, plus another $1,200 annually for future years, unless the encroachment was removed. "That seems like a lot of money for a small decorative wall," Richard said during his cross-examination. "It's not about the wall," Susan replied. "It's about the land. Land has value. Using someone else's land without permission or compensation is, at its core, theft." Jennifer also called Michelle, my neighbor, who testified about Patricia's pattern of harassment and selective enforcement of HOA rules. "I've lived in Meadowbrook Hills for 8 years, Michelle said. "I've watched Patricia use the threat of violations and fines to control people. She goes after anyone she perceives as challenging her authority." "Objection, Your Honor," Richard said. "This is irrelevant to the question of property boundaries. It's relevant to establishing a pattern of retaliatory behavior," Jennifer countered. Judge Martinez considered. "I'll allow it, but keep it brief, Miss Walsh." Michelle described several incidents of other homeowners being targeted for minor violations while board members were allowed to ignore the same rules. She mentioned the incident with her son's car and several other examples she had witnessed. When it was the defense's turn, Richard called Patricia to the stand. She wore a conservative dress and minimal makeup, clearly attempting to appear reasonable and professional. It didn't quite work. "Mrs. Henderson, when was the retaining wall in question constructed?" Richard asked. "Approximately 15 years ago, as part of the original development of the drainage system for the neighborhood." "And was it your understanding that this wall was built on HOA common land?" "Absolutely. We hired a contractor who used the original development plans. There was never any indication that we were building on private property." "Were you aware of any objections from previous property owners?" "None whatsoever. The wall has been there for 15 years without any complaints." Jennifer's cross-examination was surgical. "Mrs. Henderson, isn't it true that property modifications in Meadowbrook Hills require a survey and proper permits?" "For homeowner modifications, yes. But the HOA doesn't follow those same rules." Patricia hesitated. "The HOA is maintaining common areas. It's different." "Different how?" "Property boundaries don't change based on who's doing the building." "I'm not a surveyor. I relied on professional contractors." "Did you ever personally review a survey before authorizing construction of the wall?" Another pause. "I don't recall." "You don't recall, or it never happened?" "I'd have to review the records." "Speaking of records, can you explain why the HOA has spent over $40,000 on legal fees in the past 2 years?" "Objection," Richard said. "Relevance." "Your Honor, it's relevant to the question of whether this lawsuit against Mr. Vaughn was filed in good faith, or as part of a pattern of using legal threats to control homeowners," Jennifer said. "I'll allow it," Judge Martinez said. Patricia shifted in her seat. "We have a duty to enforce community standards. Sometimes that requires legal action." "How many of those legal actions involved homeowners who later made voluntary contributions to drop the complaints?" "I don't know what you're implying." Jennifer pulled out a printout of the HOA financial records. "I'm looking at dozens of entries labeled settlement agreement or compliance contribution. Can you explain what those are?" "Sometimes homeowners agree to make additional contributions to support the community in exchange for resolving disputes amicably." "That sounds like extortion." "Objection." Richard was on his feet. "Sustained," Judge Martinez said. "Rephrase, Miss Walsh." "Mrs. Henderson, did you file a lawsuit against Mr. Vaughn because his fence violated HOA rules, or because you were concerned he might discover the encroachment onto his property?" Patricia's face flushed red. "His fence violated multiple standards. Even though he submitted proper paperwork that was ignored by your office. We never received that paperwork. Yet we have certified mail receipts with your signature." "That wasn't my signature." Jennifer showed her the receipt. "This isn't your signature." Patricia studied it. "I sign dozens of things every week. I can't remember every delivery." "But earlier you testified that the HOA never received Mr. Vaughn's paperwork. Now you're saying you might have signed for it but don't remember. Which is it?" "I'm saying we didn't process it." "Because it was deliberately ignored to create grounds for a lawsuit." Objection. Richard was visibly frustrated now. Judge Martinez looked at Patricia over her reading glasses. "Mrs. Henderson, I'd like a straight answer. Did your office receive Mr. Vaughn's application materials or not?" Patricia took a deep breath. "It's possible we received them and they were misfiled." "Thank you," Jennifer said. "No further questions." The trial continued for most of the day. Richard called a contractor who had worked on the original drainage system. But the man couldn't provide any documentation showing that a proper survey had been done before the retaining wall was built. He admitted that it was standard practice to verify property boundaries before construction, but couldn't confirm that had been done in this case. Both sides gave closing arguments. Richard argued that the encroachment was an innocent mistake, that removing the wall would be costly and disruptive, and that I should simply grant an easement and accept reasonable compensation. Jennifer argued that property rights were fundamental, that the HOA had failed to conduct proper due diligence before building on my land, and that their lawsuit against me had been retaliatory and in bad faith. She asked for removal of the encroachment, compensation for past use, payment of all my legal fees, and sanctions against the HOA for filing a frivolous lawsuit. Judge Martinez took a brief recess to review the evidence. When she returned 20 minutes later, her expression was stern. "I've reviewed all the evidence and testimony presented today," she began. "The facts are clear. The HOA built a retaining wall on Mr. Vaughn's property without permission or proper authorization. This is a straightforward case of encroachment." Patricia sat perfectly still, her hands clasped tightly in her lap. The HOA's argument that this was an innocent mistake is undermined by their own failure to produce any documentation of proper surveying before construction. When you build on land, you have a responsibility to ensure it's land you have a right to use. The HOA failed in that responsibility. Judge Martinez looked directly at Patricia. Furthermore, the evidence suggests that the lawsuit against Mr. Vaughn was retaliatory in nature. His fence complied with community standards. He followed proper procedures for approval. The timing of the lawsuit, immediately after he installed a fence that could have prompted him to verify property boundaries, is suspicious. "Your Honor," Richard began, but Judge Martinez held up her hand. "I'm not finished. The evidence of selective enforcement and financial irregularities within the HOA is concerning. While those issues are beyond the scope of this particular case, they paint a picture of an organization that has lost sight of its purpose and has instead become a tool for harassment and control." She looked down at her notes. "Here is my ruling. The HOA will remove the retaining wall and all associated landscaping from Mr. Vaughn's property within 90 days, and will restore the land to its natural condition at their expense. The HOA will pay Mr. Vaughn $18,000 in damages for past unauthorized use of his land, plus 8% interest per annum from the date the wall was constructed." I felt Jennifer's hand grip my arm in excitement. "The HOA will also pay all of Mr. Vaughn's legal fees and costs associated with this case, including surveying fees and expert witness fees. Additionally, I'm imposing a sanction of $5,000 against the Meadowbrook Hills HOA for filing a lawsuit in bad faith." Patricia's face had gone from red to white. "Finally, while I don't have authority to dictate the internal governance of the HOA, I'm referring this matter to the Texas Attorney General's office for investigation of potential violations of the Texas Property Code regarding HOA operations." This court is adjourned. The gavel came down. For a moment, nobody moved. Then Richard was gathering his papers in a hurry, and Patricia was standing up on shaky legs. I heard her say something to Donald about calling an emergency board meeting. Jennifer turned to me with a huge smile. "We won. We won everything." "I heard," I said, still processing. "The Attorney General, what does that mean?" "It means Judge Martinez thinks something illegal might be going on with how Patricia runs the HOA. The AG's office will investigate their financial practices, governance, all of it. If they find wrongdoing, there could be criminal charges. We left the courthouse into the bright July sunshine. I felt lighter than I had in months, as if a weight I hadn't fully acknowledged had been lifted off my shoulders. Over the next few weeks, the fallout from the trial spread through Meadowbrook Hills like wildfire. George told me that the emergency board meeting had devolved into chaos, with Patricia insisting everything would be fine, and Donald trying to figure out where the HOA would get the money to pay the judgment. They had to tap into the reserve fund, George said. The money that was supposed to be for emergency repairs and maintenance. People are pissed. Michelle reported that a group of homeowners had started a petition to recall the entire HOA board and elect new leadership. "You've become a bit of a folk hero," she told me with a laugh. "The guy who stood up to Patricia and won." "I just wanted to keep my fence," I said. "Yeah, but you exposed the whole rotten system. People are realizing they don't have to live in fear of violation notices and threats." The Texas Attorney General's office sent investigators in August. They reviewed the HOA's financial records, interviewed current and former board members, and talked to numerous homeowners about their experiences. I gave a statement describing my interactions with Patricia and the lawsuit. In September, the investigation concluded. The AG's office announced that Patricia Henderson, along with the HOA's former treasurer, someone who had left the board before I moved in, would face charges for theft and misapplication of fiduciary property. Apparently, the voluntary contributions George had mentioned were more systematic than anyone realized. Patricia had been essentially extorting homeowners for years, and a significant amount of that money had been diverted to personal use rather than HOA funds. "She's looking at serious jail time," Jennifer told me over the phone. "The evidence is pretty damning." Patricia resigned as HOA president immediately. Donald resigned too, claiming he had been unaware of any wrongdoing but didn't want to be part of the cleanup process. A special election was held in October, and a whole new board was voted in. The new president was a retired accountant named Harold who promised transparency, fair enforcement of rules, and no more harassment campaigns. The retaining wall was removed in late October, just before the 90-day deadline. The HOA hired a landscaping company to restore my property, adding new topsoil and grass seed to blend the area with the rest of my lawn. The work was done professionally and without complaint. The check for damages and legal fees arrived in November. $28,000, including interest and costs. It was more than enough to cover everything I had spent, and then some. I stood in my backyard on a cool November evening, looking at where the wall had been. The grass was still patchy in spots, but you could see new green shoots coming up. Give it a few months, and you'd never know anything had been there. George wandered over with his usual offering of beer. Heard Patricia took a plea deal. 3 years probation, restitution, community service. Could have been worse, I said. Could have been better, but at least she's out of our hair. George settled into a patio chair. The new board is actually asking for input on rule changes. It's like living in a different neighborhood. Michelle stopped by shortly after, carrying a homemade pie. "Apple crumble. Consider it a thank you for making this place livable again." "You didn't have to do that," I said, but accepted it gratefully. "I wanted to. You know, before all this happened, I was seriously considering moving." The constant stress of wondering what Patricia would find to complain about next was exhausting. Now it feels like an actual community again. We sat on the patio as the sun set, the three of us talking about nothing in particular. Neighborhood gossip, upcoming holidays, George's plans to finally train his dogs properly. Normal stuff. The kind of stuff that should be normal in a neighborhood. Later, after they had gone home and I was alone with my thoughts, I reflected on the past several months. It had been stressful, expensive, and time-consuming. There were days I had wondered if fighting was worth it, if I should just take a settlement and move on. But I was glad I fought. Not just for myself, but for everyone Patricia had bullied over the years. For Michelle, who had been harassed over her son's car. For George, who had paid extortion money rather than face legal threats. For all the unnamed homeowners who had lived in fear of violation notices and fines. The fence still stood, solid and straight. It kept George's dogs in their own yard, gave me privacy, and served as a reminder that standing up for yourself matters. Sometimes you have to fight, even when it's difficult, even when people tell you to just give in and accept the easier path. My phone buzzed with a text from Jennifer. Saw the news about Patricia's plea deal. Justice served. Proud of you for seeing it through. I texted back. Thanks for everything. Couldn't have done it without you. That's what good lawyers are for. Call me if you ever need anything. And enjoy that fence. I smiled and looked out at my yard. The fence was just a fence, nothing special. But it represented something more now. It represented the idea that ordinary people could stand up to petty tyrants and win. That rules applied to everyone, not just the people without power. That property rights mattered, and couldn't be trampled just because someone had a title and a laminated binder full of regulations. The HOA nightmare was over. Patricia Henderson was facing consequences for her actions. The neighborhood was healing under new leadership. And I had my fence, my property rights, and my peace of mind. As I headed inside for the night, I made a mental note to build a small patio next spring. The new HOA board had already streamlined the approval process and promised reasonable response times. Maybe I'd add a fire pit too, make the backyard even more enjoyable, but first, I'd check the property lines carefully. Measure twice, cut once, and maybe hire Tom for another survey just to be absolutely sure. After everything I'd been through, I wasn't taking any chances. The November wind rustled through the cedar boards of my fence, and I felt genuinely content for the first time since moving to Meadowbrook Hills. It had been a long, difficult fight, but I had won, and more importantly, I had helped change things for the better. Sometimes the best thing you can do is stand your ground, refuse to be bullied, and trust that the truth will prevail. It doesn't always work out that way, but this time it had, and that made all the difference.